With us, joining us is Nicole Sauer and Mr. Blaine McDonald. Next on our agenda is Bill number 144, the Police Miscellaneous Amendment Act 2023. Minister Merriman is here with his officials. I will remind the officials to identify themselves for the record before they speak and do not touch the microphones. Hansard operator will turn them on for you. We will begin our consideration with Clause 1, short title. Minister Merriman, please make your opening comments and introduce your officials.
Thank you very much, Mr. Chair. I'll now offer my opening remarks for Bill 144, the Police Miscellaneous Amendment Act. With me, I have Greg Goodlow, and I also have Neil Carcutt. This bill contains two sets of changes. First, the bill creates new provisions respecting the Saskatchewan Marshal Services. The Saskatchewan Marshal Services is a police service that will provide an additional law enforcement presence across Saskatchewan. Its duties will include detecting, disrupting, and deterring criminal activity, primarily in rural and remote areas, conducting proactive investigations into offenses relating to farming and agriculture, enforcing provincial and federal statutes, locating and apprehending high-risk and prolific offenders with outstanding arrest warrants, and providing emergency and specialized support to other law enforcement services. The Saskatchewan Marshal Services was established by Order in Council last August in accordance with Section 24.1 of the Act. This was an interim step to allow staffing and procurement process to begin, including the appointment of Rob Cameron as Chief Marshal. The proposed amendments designate the Saskatchewan Marshal Services as a police service through legislation and sets out details respecting its structure, operation, and governance, as well as collective bargaining and human resource matters. Under the proposed legislative structure, a Chief Marshal will administer and manage the Saskatchewan Marshal Services operations and maintain discipline. The Minister will work with the Chief Marshal to develop long-term strategic priorities. The legislation expressly prohibits the Minister from providing direction respecting investigations, the conduct of operation, the discipline of members, or the day-to-day administration of the Saskatchewan Marshal Service. And Saskatchewan Marshal Service Governance Advisory Council will advise the Minister on the Minister's powers and the duties respecting the Saskatchewan Marshal Services. Additionally, the Deputy Minister will act as the board while dealing with public complaints, collective bargaining, and serious incidents. This legislative structure ensures that the Saskatchewan Marshal Service can carry out its own duties and mandates independently without political bias. The second set of changes to the Act's provisions respecting the Serious Incident Response Team, or CIRT. First, the changes create a warrant process to allow CIRT to obtain evidence from third parties that will assist with investigations. Currently, if CIRT requires a third-party evidence and the third party is not cooperative, a warrant is required under the Criminal Code. That warrant process requires a reasonable belief that a criminal offense was committed. Specific warrant powers for CIRT will help ensure transparency and public confidence in policing, even in cases where there are no grounds to believe an offense was committed. Appropriate rules and processes are included to ensure the privacy rights of third parties are respected. These changes also update matters respecting notices and timing requirements. Most of these changes are currently addressed through regulations, but it will now be clarified under the Act. With that, Mr. Chair, I welcome questions to Bill 144, the Police Miscellaneous Amendment Act 2023 from the committee. Thank you.
Thank you, Minister. We'll open up for questions now. Ms. Sauer.
Thank you, Mr. Chair, and thank you, Minister, for your opening remarks. I have a few questions about some changes in the bill. I will try and go through them from start to finish, but I might end up jumping around based on our conversation. The first provision I wish to ask a question about is in relation to Section 5 of the bill, which repeals subsection 24.1 sub 5 of the legislation. Can you explain why this subsection is being repealed?
Neil Carcutt from the Ministry of Justice and Attorney General. As the minister mentioned previously, initially the marshals were established by order in council through section 24.1. In the previous set of amendments to the Act, there were some updates made to that section to accommodate the development of the marshals, and one of them being that subsection 5 you see there. As a default, it's anticipated that the police commission regulations will apply to the marshals. However, those commission regulations are very detailed, so in some instances it might be necessary to create specific regulations to the marshals. So for example, if a logo is different than set out in the regulations, or some of the clothing or equipment requirements differ slightly from what the commission sets out in its normal regulations. So that power was established at that time in case that needed to occur. Those types, no specific regulations have been passed yet. However, now that the marshals are going to have their own specific provisions under the Act, the legislation is removing that general provision, and it will be under the marshal specific provisions that those unique regulations can be passed.
Thank you. I'm now looking at section 36.11, which is a part of the new Part 3, as you're saying, this distinct part of the bill that includes the Saskatchewan Marshals Service. So going back to my question, 36.11 sub 2 speaks about something that you have alluded to in your opening remarks, Minister, that there will be consultation with the minister around direction, policy, strategy, or plans. That's clearly contemplated in this subsection of the Act. Can you provide some examples of what that might include?
Thank you for the question. As it was addressed in my opening comments, this would be providing overall very high-level direction to the Marshal Service for making sure that they're in compliance with the Police Act, and making sure that any needs that they are requiring as far as financial needs, that those are brought to my attention to be able to make sure that there's budgetary dollars for that. But it wouldn't be, as I identified, anything to do with day-to-day operations or anything to do with specific investigations, that no different than any other police services in the province.
Sorry, you said at the very end, no different than any other police service within the province. Do you mean police service that answers to like it's similar to how a police service answers to a police board? That's what that relationship will be?
You mentioned the board. The deputy minister would step in where a board would traditionally act with the police service. So an example for that would be in human resource matters, in collective bargaining, in some instances, for example, with a public complaint, the board might play a role. So it's the deputy minister that would be playing those roles with the marshals.
Thank you for that clarification. This provision deals directly with the minister, and I see now the minister's spoken a little bit about what this provision means broadly. He mentioned high-level direction. Can you provide some more detail as to what that would look like, for example?
So, like I had talked about, some of the general goals would be, and as I identified, there's going to be no hands-on from the minister in any of direction as far as investigation or day-to-day. But like I said, it's very similar to other police technically under the Act. The RCMP in Section 5.1 indicates that the RCMP Commissioner is under the direction of the Minister of Public Safety and Emergency Preparedness. Is very similar to what that is. Again, duties include detecting, disrupting, and deterring criminal activity, proactive investigations into offenses, enforcing provincial and federal statutes, locating and apprehending high-risk offenders, providing emergency and specialized supports. These are some of the duties that the Marshal Service will be able to execute once they are up and running.
Thank you. I understand what the legislation disallows the minister to be involved in specifically, but I am asking around more detail as to what the minister is allowed to do provided under sub 2. So there are clear words here like direction, policy, strategy, or plan in 36.11 sub 2. And I'm wondering if you can provide more detail than you have provided as to what that could mean for the Marshal Service.
Well, I would think it would be very similar to what I do right now when I meet with the Saskatchewan Association of Police Chiefs. When I talk to them, I talk to the Commissioner of RCMP, not providing specific direction, but providing support for those individual agencies and agencies working together, working with the RCMP, working with municipal police. I interact with chiefs of police and not providing specific direction, but providing support in their doing. And any direction that is provided is at very, very high level and has nothing, like I said, mentioned, it has nothing to do with the day-to-day operations or any execution. The marshals will be an independent organization from the ministry. It's very similar to what I do with other agencies. I check in with them, how I can support them, how I can make sure that their budgetary needs are being met, and try to work as coordination of these different entities through my office.
Thank you, Minister. As you know well, words matter in legislation. You've mentioned that you see the role as one being a support role to the marshals. However, support is not used in that provision. There are direction, policy, and strategy are the three words that are used. Do you have any comments as to, are you able today to provide further detail as to what that is going to look like?
So I guess just an example of the strategic direction that you might see is what the minister had originally gone over. For example, the SMS's duties involve, detecting, disrupting, and deterring criminal activity primarily in rural and remote areas, locating and apprehending high-risk and prolific offenders with outstanding arrest warrants. The marshals are going to be carrying out specific duties in those types of listed areas. That's an example where the minister would be providing high-level strategic guidance on what their roles and duties are to carry out. They're not the police force of original jurisdiction. They're going to be carrying out those specialized duties. And so that's, I guess, one of the best or clearest examples you can provide of what type of strategic direction and policy the minister would be providing to them.
You mentioned that the deputy minister will be acting as the board in a traditional sense. I'm just looking at the definition of, or not the definition, but the the Regina Police Service Board of Police Commission's website, where they outline what their responsibilities are. One of them is the board establishes the objectives and priorities of the Regina Police Service. So will the deputy minister be serving that role, or will the minister be serving in that role?
I guess as I identified in my opening comments, the deputy minister will act as the board dealing with very high-level public complaints, collective bargaining, and serious incidents. That would be where the deputy minister's role is on the operation. Then it would be talking, as far as the specific operational side of things, that would be up to the chief marshal. And I also mentioned that there would be an advisory committee that will be made up of community members that will also assist in providing direction, which will be made up of organizations such as SARM, SUMO. We will work with First Nations to find an additional person from our Indigenous, representing our Indigenous community, as well as rural and remote areas. So we will make sure that that advisory committee is in place to also help advise myself as well as the deputy minister, if need be, or the chief marshal.
We'll get to more detail. I'll ask some questions around the advisory council as well shortly. So I'm just looking at 36. I was talking about 36.11, but in addition, there's 36.4, the role of the minister. You've talked a lot about what the minister will not do. And then here where it says in sub 1, sub A, that the minister shall provide general direction, policy, and priorities to the chief marshal respecting the SMS. So it looks like that role, as you have just described, Minister, what the specifics of the DM will be, the DM role, that policy and direction will, the high level, as you've described it, will come from the minister specifically. Now, you've spoken a bit about the role of the marshals and what their duties will be. And I know that is also laid out here in terms of 36.3 around members. I just have a few questions about the scope of work for the marshals. Now, you mentioned in your opening remarks, Minister, that they will be focused on the rural and remote areas of the province. Is that correct?
Rural and remote, but also helping to assist other police force in backfill if there's any requirement for that to happen.
They will be based out of Prince Albert. Is that correct?
That's yeah, they'll be headquartered out of PA, and it'll be up to the chief marshal to decide operationally where he feels individual postings will be.
So have there been any decisions yet as to where those individual postings will be, or how many of them there will be in the province?
I don't think so. The chief marshal hasn't identified anything. I would leave it up to his discretion as to where they are. He wouldn't necessarily, it's an operational issue.
Piece of that be a funding issue, though, from the government? I'm assuming with individual postings, there will be buildings and equipment and the like that will need to be purchased through the ministry. Is that correct?
That hasn't been determined yet.
So the only thing that has been determined so far is where the headquarters will be?
That's correct. I assume that the chief marshal is looking at a plan operationally on where he feels that the marshals will be the most effective, but they will be mobile throughout the province. It's just more where they're posted. But that would be an operational decision based on his experience as a former police officer himself.
Has that building been purchased yet for that headquarters?
No. Yes, there is a building that has been purchased for that. It was leased, my mistake.
Okay, what is the price of the lease?
And I'm not sure what that has to do with the piece of legislation, but it would be within budgetary dollars that have been allocated to the chief marshal.
Much?
I don't know how much it is. It's within the chief marshal's budget.
Could you provide that number to the committee at a later date?
Again, I'm not sure what that has to do with the legislation. It's an operational decision. This is a high-level strategic legislative bill that is not into the operation. I feel we're very deep into the operations of the chief marshal. That I don't think that has anything to do with the piece of legislation in front of us.
Just for clarity of the committee, are you refusing to provide an answer to that question?
I'm not refusing to provide any answer to it. I'm talking about the piece of legislation in front of us. Those would be something that could be done through written questions, question period, or through estimates. We're talking about a piece of legislation in front of us, not necessarily the operations.
Asking about the marshal service and how it's going to operate, which is what this legislation is doing. A piece of that involves purchasing equipment, purchasing buildings, hiring staff, and I think it's imperative on us as legislators to ask the ministry and yourself as minister what the costs are associated with that, with respect to this bill.
And we've been very clear with that. The startup costs this year were $7 million, which was budgeted, which was gone through the legislative process. And we're looking at the budget for next year, which is everything that you are asking about is encompassed in that budget. So if there's some budgetary questions when that comes, we'd be more than happy to answer those budgetary questions. We're speaking specifically about the legislation, not about the budget.
So are you saying that any expenses related to the lease did not happen in this budget term, that it will be in the following budget? Like it's not coming into effect until April 1st?
What I'm saying is that there's $7 million allocated in this year's budget for the marshals and $20 million in next year's budget for that, which we've been very transparent about. All of the costs that are going to be incurred for the lease, the vehicles, the equipment, the outfitting of the specific officers, the training of those specific officers are all within that budgetary number.
So just to clarify, the cost of the lease falls within the $7 million allocation that was provided for this budget cycle?
That's what I've been told, yes.
Okay, but you will not provide us the exact number?
No, I don't have the exact number.
Okay.
We're talking about two different things. We're talking about a budgetary number versus a piece of legislation. A piece of legislation does not necessarily, there's nothing in this legislation about dollars. That's a budgetary issue that we can discuss at a financial committee meeting, absolutely. I'm just not sure what that actually has to do with the piece of legislation in front of us, because the budget has been set and is being adhered to.
Well, again, it deals with the operations of the Marshal Service, which is what this legislation is designed to do. I will move on because you're not going to answer that question. Can you provide some more details as to what the scope of the work of the Marshal Service will be?
Are you talking about this?
Talked about warrant enforcement, and you had talked about that in your opening remarks.
Yeah, I can go through it, sure. The duties will include detecting, disrupting, and deterring criminal activity, primarily in rural and remote areas, conducting proactive investigations into offenses related to farming and agriculture, enforcing provincial and federal statutes, locating and apprehending high-risk and prolific offenders with outstanding warrants, and providing emergency and specialized support to other law enforcement services, which I think is a very big piece of the marshals that might not be understood by the general public, that we will be able to backfill and help support municipal policing as well as RCMP with marshals, so we can keep more officers in the field versus them being pulled off to do special duties.
So you mentioned municipal backfill. Is that being done at the request of municipal police forces?
Well, in a situation where just recently the Prince Albert Police was one of the recommendations came out that they needed to form a special task force or a special group of officers, and they said it was very difficult and challenging for them to do that because they have officers that are being used in other capacities. So this is where the marshals can come in and backfill those positions to help out, so those officers would be able to go out onto this special task, and marshals would be able to help them and provide some support in behind those municipal or RCMP, depending on what the task force is.
I'm actually curious to know how that's going to work operationally. So if the marshals are coming in to support municipal forces, are they then answering to and taking direction from the police chief of that jurisdiction, say the PA chief, for example, or are they taking direction from the chief marshal?
Well, I think it would be something, it would be requested by the municipality for them that they need some support in there, that the chief marshal would be able to, if the chief marshal is able to allocate that support out to that specific police force. That would be an operational decision, no different than when we have a lot of our task force, our crime reduction team are made up of municipal and RCMP, so they work in conjunction together, not necessarily reporting to the municipality or the RCMP, but they have a specific task in their crime reduction team, our warrant enforcement team. The marshals would dovetail into that very similar and be able to assist wherever they're needed. And that's why bringing an additional 70 officers in to Saskatchewan to be able to address this and be able to help out and support other municipalities is being very positively received by the Saskatchewan Association of Chiefs of Police.
Sorry, are you saying that the Marshal Service has been very positively received by the Saskatchewan Association of Chiefs of Police?
I would say that, yes, the police officers that I've spoken to are supportive of that, the chiefs that I have talked to. The RCMP had some initial concerns, but we're certainly working that out with them and how this is not pulling away from RCMP officers. And I think that's a very important point is we are funding the RCMP. We're looking at increasing the funding for the RCMP. We're not taking any money away from the RCMP to fund the marshals. We were able to fund the RCMP an additional $13 million in this fiscal year. So we are supporting the RCMP. We are supporting our municipal police force, our First Nation, and now we will be supporting the marshals.
Has been a concern about poaching, whether or not this service will, instead of adding more bodies to Saskatchewan, will just move bodies from one policing force to another. Do you have any comments on that?
Well, it's I can't leave that up to the chief marshal as far as who he is hiring and who he is not hiring. We've had lots of interest from outside the province. I think we've had over 125 resumes come in of seasoned officers that would like to be a part of this. They certainly see the value of the marshals as law enforcement, and we would do our best to make sure that we're not pulling from one police force to be adding into another police force. We would make sure that we keep them as whole as possible. In saying that, we want to make sure that we have the most effective marshal force out there as well.
What is the starting salary for a marshal?
As I've been told, we're going through the process of the public service to be able to determine their salary, but it will be somewhat comparable to other law enforcement at that level.
Thank you. What is the salary of the chief marshal?
Again, I think we're venturing off into budgetary questions again, and I understand where you're trying to go with this, Ms. Sauer, but we just hired the chief marshal as of January 1st. It would be the equivalent of a police chief in other areas, such as Prince Albert, Chief Noge, in and around that specific area. But we're really venturing into budgetary questions, not policy questions.
Thank you. I understand you have the number and are not providing it to the committee at this time. I will ask it again at estimates. I'm going to move on to the Governance Advisory Council, which you touched on very briefly. Minister, can you provide some further explanation as to what their role will be?
So the SMS Governance Advisory Council, that was based partly on Ontario's new policing legislation, so we modeled that partially off their approach. And I guess the best way to describe the role of the Advisory Council goes back to what the minister was describing as there's the role of the minister to provide general policy and administrative oversight, and then the role of the chief marshal who really runs the operational day-to-day, the investigations, those elements. So the Advisory Council, I guess, helps maintain an extra level of oversight to ensure that independence and separation of roles.
So it says, so just walk me through how that's going to work, and the ensuring the independence of the roles, or the separation of the roles. Sorry, I can't remember if you said separation or independence.
I get separation works.
7 speaks specifically about what the role of the Advisory Council is. It looks like the minister, if they want to, they're not required to, but they can submit, for example, a policy to the Advisory Council, who will then determine whether or not the minister is able to provide that policy to the SMS. Is that correct?
That would be a correct description. I would just add that there's two branches. So the minister may submit a policy, for example, to the advisory council. But if you also look at subsection 3, the advisory council can request that the minister provide a direction or policy or strategy as well. So if there was something in the works or something recently introduced, they could also request that be provided so they could initiate the review as well.
So what happens after that review concludes?
That would be, I guess, there we go. 4B would be, I guess, the main description there is they can provide any advice or recommendations to the minister with respect to the direction, policy, strategy, or plan. It's an advisory role.
So would their recommendations ever be publicly available?
Yeah, that's addressed in subsection 5. The minister, it's in the minister's discretion, but may publish any advice they receive in the manner that the minister considers appropriate.
You hit the piece that I wanted to ask about. It's a may clause, not a shall clause. Why was that drafted in that way?
That's essentially to protect the operational integrity of the marshals. When you're dealing with the types of, for example, there might be a policy or strategic initiative looking into gang activities where we don't want to be, or the marshals don't want to be publishing the details of those operations because it could be a very sensitive area that would impact policing operations. So that's the main reason why the legislation leaves that as discretionary.
Thank you. I have a very specific question around 36, now I'm going back, 36.5 sub 2, which is around indemnifying members for costs in the cases of criminal prosecution. Now, if you look at the end of sub 2, it says, the minister may indemnify the member for all reasonable costs incurred in the defense of the criminal prosecution. Now, my understanding is most municipal police collective bargaining agreements actually require their employer to indemnify members. Could you explain why there is a difference between what municipal police members receive in their CBA and what the Marshal Service members will receive pursuant to this legislation in terms of indemnification?
Okay. When this piece was reviewed, there was concern that, and this is not to, there may be instances where you would have a police officer who was acting in a negligent or criminal matter, and it's not appropriate to be indemnifying them for their criminal prosecution, for example. So that was the reason it was determined to make this a discretionary power.
Thank you. I forgot to ask a question about the advisory council when we're on it, so I'll go back to it. You mentioned that the board will consist of at least 3 members. Do you have any idea yet how big that board is going to be? You had mentioned, Minister, some of the stakeholders, organizations that you anticipate will form part of the advisory council. I'm just wondering what more work has been done with respect to the what the board's going to look like.
I think I can tell you this, there's been a lot of stakeholders that have approached us that said that they would like to be involved with this as it is a new initiative. We've had lots of groups like the Cattlemen's Association, SARM, SUMA have specifically asked if they could be involved with this. I gave them my verbal that yes, they would be involved. We would make sure that SARM and SUMA have a representative. Now, whether that's the president or a designate, because I think it's very important that the marshals look at what's happening rural and urban as well. Some First Nations, I don't have the size of that made up, but I would like to be able to make sure that it's inclusive of northern communities, rural communities, as well as First Nation communities. We've had a very preliminary discussion with some Métis communities as well to see if they would be interested. I haven't got the total number of how many people would be on that board. I would like it to be effective. Usually, I would think 8 to 10 would be maximum. Just otherwise, it gets too convoluted, and I want to make sure that they're very focused on helping me make decisions, or helping the minister make the decisions, and also helping out with the chief marshal.
Thank you. I also use the word board. I need to be more careful with my language. Advisory council, just to be specific. Do you have a timeline for when the advisory council will be formed?
I don't have a specific timeline, but we've had a lot of interest, so we're just gathering the information, and we're going to set up a matrix to make sure that we do have a robust advisory council. But we do have a lot of interest from a lot of our stakeholders right now. It's hard to provide an advisory council without operationalizing the marshals, but we'll make sure that we are meeting with lots of stakeholders right now, and not as an advisory capacity, but in an unofficial capacity, and they're providing lots of great input to us, especially SARM and SUMA.
Thank you. Do you have a timeline for when the marshals will be operationalized?
2026.
Okay. You had mentioned, in terms of scope of duties of the marshals, a focus on rural and remote areas of the province. As I'm sure you well know, one of the main challenges that the RCMP are faced with right now in Saskatchewan is the exponential file load of the officers who are working north of Prince Albert. And as a result, RCMP have had to shift resources from the south of the province to the north of the province. Will the Marshal Service be addressing some of the challenges that are being faced currently north of Prince Albert?
There's a few things that have to happen north of Prince Albert. Certainly the marshals are a piece of that, but obviously not addressing that issue until we're operationalized in 2026. And it's also how we can help Assistant Commissioner Blackmore fill up her roster of individuals, not just in the south, but in the north and all areas of the community. I think she's done an amazing job of opening up recruits' eyes that are from different parts of the country to be able to fill that. So the marshals are a piece of that. They're not going to fix all of the gaps that are out there from the RCMP. As we sit right now in the last, we're about 16% short on our RCMP complement, either hard or soft vacancies. The marshals can't fill that. We need to raise all of our police forces, whether they be municipal, First Nation, marshals, or the RCMP. We need more officers, especially in the north, because there are some unique challenges. And it does take a unique individual to be able to work in the north just because of the geography and the culture that is up north. There's a lot of nuances to that. So we want to make sure that we're supporting the RCMP to be able to fill those spots, as well as helping out with the marshals to be able to fill in some of those gaps to assist the RCMP.
Thank you. I have no further questions.
Perfect timing. Seeing no more questions, we'll proceed to vote on the clauses. Clause 1, short title, is that agreed? Agreed. Carried. Clause 2, is that agreed? Carried. Clause 3, is that agreed? Carried. Clause 4, is that agreed? Carried. Clause 5, is that agreed? Carried. Clause 6, is that agreed? Carried. Clause 7, is that agreed? Because clause 7, 2 pages. Carried. Clause 8, is that agreed? Carried. Clause 9, is that agreed? Carried. Clause 10, is that agreed? Carried. Clause 11, is that agreed? Carried. Clause 12, is that agreed? Carried. Clause 13, is that agreed? Carried. Clause 14, coming into force, is that agreed? Carried. His Majesty, by and with the advice and consent of the Legislative Assembly of Saskatchewan, enacts as follows: the Policeman Miscellaneous Amendment Act 2023. I'd ask a member to move that we report Bill number 144, the Police Miscellaneous Amendment Act with 2023 without amendment. Mr. Kiesig moves. Is that agreed? Carried. Minister, do you have any closing comments?
Just thank my officials. I thank Ms. Sauer for the respectful discussion. And as my quick comment is I think this is my first bill under His Majesty. So it was one little nuance there that I caught. But thank you very much to all my officials, and thanks very much to the committee for their time this evening. Thank you. Ms. Sauer, any closing comments?
Just join with the minister in thanking yourself, Mr. Chair, and the rest of the committee for their important work, as well as the minister for his and his officials for their thoughtful responses to my questions, and just thanks to everyone within your ministry, including those behind you, for all the work that they do in serving the province every single day.
Thank you. I too would like to thank the minister and the staff and all the colleagues here that are here tonight as well. We'll now take a brief recess to change officials. everybody back, and we have Minister Eyre here with her officials for consideration of our remaining bills. I would remind officials to identify themselves for the record before speaking and not to touch the microphones. Hansard operator will do them for you. We will begin with Bill number 140, Miscellaneous Statutes Repeal Act 2023, Clause 1, short title. Minister Eyre, please make your opening comments and introduce your officials.
Absolutely. So thank you, Mr. Chair. I'm here with Darka Tkach, Crown Counsel Legislative Services, Darcy McGovern as well. And this is Bill 140 as stated. And to that bill, Mr. Chair, we are always reviewing legislation to identify any statutes which have become outdated or obsolete. These include older acts that are no longer relevant, acts that have been replaced by new legislation, private acts where nonprofit organizations have ceased operations. And this year there are 8 acts proposed for repeal. 3 of these are public. The Names of Homes Act from 1927 has had its purpose partly assumed by the Business Names Registration Act. The Saskatchewan Advantage Grant for Education Savings, or SAGES Act, oversaw a program of provincial education grants which ended in 2017. An act respecting the summer resort village of Carlisle Lake Resort is out of date, as what is now the White Bear Lake Resort is currently managed by the White Bear First Nations. And the other 5 acts to be repealed are private acts relating to nonprofit organizations which are no longer operating as corporate entities in the province. These are an act respecting the Canadian Bible Society Saskatchewan District, an act to incorporate Sacred Heart Academy, an act to incorporate the Catholic Women's League, an act to incorporate Herbert Bible School Association, and an act to incorporate the Wildlife Foundation of Saskatchewan. In preparing this bill, officials have worked with officials from other ministries and stakeholders to confirm that the proposed repeal of legislation is appropriate. And with that, I welcome questions respecting Bill 140, Mr. Chair.
Thank you, Minister. I'll now open it up for questions. Ms. Saar.
Thank you, Mr. Chair. Minister, thank you for your opening remarks. In your opening remarks, you've answered all of the questions that I had with respect to this bill, so I have no further questions.
Seeing as there was no questions, not more questions, we will proceed with the vote on the clauses. Clause 1, short title, is that agreed? Agreed. Carried. Clause 2, is that agreed? Agreed. Carried. Clause 3, is that agreed? Agreed. Carried. Clause 4, is that agreed? Agreed. Carried. Clause 5, is that agreed? Agreed. Carried. Clause 6, is that agreed? Agreed. Carried. Clause 7, is that agreed? Agreed. Carried. Clause 8, is that agreed? Agreed. Carried. Clause 9, is that agreed? Agreed. Carried. Clause 10 coming into force, is that agreed? Agreed. Carried. His Majesty, by and with the advice and consent of the Legislative Assembly of Saskatchewan, enacts the follows: the Miscellaneous Statutes Repeal Act 2023. I'd ask a member to move that we report Bill number 140, the Miscellaneous Statutes Repeal Act 2023, without amendment. Mr. Gruel moves. Is that agreed? Agreed. Carried. Is there any closing comments on none of the questions?
No.
Thank you. Ms. Saar, you have none? Okay, we'll move forward. Next on our agenda will be Bill number 141, Statute Law Amendment Act 2023. We will begin our consideration with Clause 1, short title. Minister Eyre, please make your opening comments and introduce your officials.
Okay, thank you, Mr. Chair. This bill will make housekeeping changes to a number of acts. The changes won't have substantive impact on the acts being amended, but they fit into the policy of keeping legislation up to date. Cross references and language errors will be corrected in the Animal Production Act, the Architects Act 1996, the Business Corporations Act 2021, and the Saskatchewan Technology Startup Incentive Act. Provisions relating to the new application for leave to appeal process will be added to the Insurance Act and the Securities Act 1998. References to repealed acts will be replaced with the current applicable legislation in the Enforcement of Money Judgments Act, the Public Guardian and Trustee Act, the Public Health Act 1994, and the Summary Offences Procedure Act 1990. Redundant or out-of-date provisions will be repealed in the Personal Property Security Act, the Public Pension and Benefits Administration Corporation Act, and the Time Act. The name of a government branch will be updated in the Medical Laboratory Licensing Act 1994. Finally, references to Her Majesty will be amended to say the Crown or His Majesty in the Justice and Attorney General Act, the Provincial Sales Tax Act, and the Sale or Lease of Certain Lands Act. And Mr. Chair, with those remarks, I welcome any questions.
Thank you, Minister. I'll open it up for questions. Ms. Saar.
Thank you, Minister, and thank you, thank you, Mr. Chair, and thank you, Minister, for your opening comments. As you had mentioned, there were several changes. There are several changes in this legislation, all housekeeping. One of those being a change to pieces of legislation to make the language gender neutral. What other work is the ministry doing to ensure that language throughout all legislation is gender neutral?
Thank you. The role of our drafters on an ongoing basis with respect to all the legislation that is coming forward has been to identify methods for dealing more specifically with the officers. As you know, in the old days, it was he. That was how the references defaulted to, and that became he or she, and it became clear that it was more appropriate to, in cases where they could, refer instead to the officer, to the sheriff, to the office of the director of land titles, for example. And then that was simply a more appropriate way to do it. And at this point, that's been a very effective way to bring the legislation forward without having to be specific with respect to the gender changes. And our drafters view that as a standing challenge and something that they try and do.
Legislation is being continually reviewed for that purpose.
That's correct. As you know, in Saskatchewan, we haven't had an approach of saying, since 1978, a full revised statutes of Saskatchewan. Instead, the policy and the direction of Cabinet and the ongoing direction of the ministers has been to continually seek to refresh the legislation and do that on a consistent policy basis.
No further questions.
Seeing as we have no more questions, we will proceed to vote on the clauses. Clause 1, short title, is that agreed? Agreed. Carried. Clause 2, is that agreed? Agreed. Carried. Clause 3, where's that? 3, is that agreed? Sorry. Agreed. Carried. Clause 4, is that agreed? Agreed. Carried. Clause 5, is that agreed? Agreed. Carried. Clause 6, is that agreed? Agreed. Carried. Clause 7, is that agreed? Agreed. Carried. Clause 8, is that agreed? Agreed. Carried. Clause 9, is that agreed? Agreed. Carried. Clause 10, is that agreed? Agreed. Oh yeah. Carried. Clause 11, is that agreed? Agreed. Carried. Clause 12, is that agreed? Agreed. Carried. Clause 13, is that agreed? Agreed. Carried. Clause 14, is that agreed? Agreed. Carried. Clause 15, is that agreed? Agreed. Carried. Clause 16, is that agreed? Agreed. Carried. Clause 17, is that agreed? Agreed. Clause 18, is that agreed? Agreed. Carried. Clause 19 coming into force, is that agreed? Agreed. Carried. His Majesty, by and with the advice and consent of the Legislative Assembly of Saskatchewan, enacts the follows. Statute Law Amendment Act 2023. I'd ask a member to move that we report Bill number 141, the Statute Amendment Law Act 2023 without amendment. Mr. McLeod moves. Is that agreed? Agreed. Carried. Any closing comments on this bill? Hearing none. Ms. Saar, you're good. Okay, we'll be moving on to consideration of Bill number 145, the Funeral and Cremation Services Legal Decision Maker Protection Amendment Act 2023, Clause 1, short title. Minister, please make your opening comments.
Thank you, Mr. Chair. And with me, Maria Marcotis, Senior Crown Counsel, Legislative Services Branch with the Ministry of Justice, and Denny Hugabert, Executive Director, Consumer Protection Division, Financial and Consumer Affairs Authority of Saskatchewan. So thank you, Mr. Chair. I'm pleased to offer opening remarks on, as stated, Bill 145, the Funeral and Cremation Services Legal Decision Maker Protection Amendment Act 2023. This bill amends the Funeral and Cremation Services Act to make important changes to the priority scheme for decision-making regarding the disposition of human remains. When a death occurs, it can be, of course, a very difficult and emotionally charged time for family members. In some cases, the family members of a deceased person cannot agree on how the remains of the deceased should be disposed of, and specifically where there's no executor and family members cannot agree. This bill amends the Act to create a distinction between the legal decision maker for a child and another parent. And Mr. Chair, this distinction is necessary because where persons in the same category disagree, the oldest is currently given priority, despite not perhaps having had a legal decision-making responsibility for a child. The amendments will instead give priority, a decision-making responsibility over the disposition of remains in these circumstances to a legal decision-maker appointed by the court. The proposed amendments also include some housekeeping changes, and with those opening remarks, Mr. Chair, I welcome questions regarding this bill.
Thank you for your comments, Minister. We'll open it up. Ms. Saar.
Thank you, Mr. Chair, and thank you, Minister, for your opening comments. I have a few questions with respect to this legislation or this bill. The first one being Section 6 of the bill, which repeals subsection 25 sub 6. Could you provide some explanation as to why this particular subsection is being repealed?
Thank you, Maria Marquetos, Legislative Services Branch, Ministry of Justice and Attorney General. This amendment is entirely around clarifying the terms for members appointed to the Funeral and Cremation Services Council. So 25 sub 6, which is being repealed, applies only to members who are applied pursuant to Clause 1A. Those members were the ones who were appointed back in 1999. They were at that time entitled to be appointed as part of the first council and then for 2 additional 3-year terms. Current members are entitled to hold office under 26(2) for 2 consecutive terms. So to avoid any issue about which section applies, we're repealing this section to make it clear that 26(2) applies.
Thank you for that. Now, the crux of this bill is around Section 91 and who will be an authorized decision maker. And I think, Minister, you laid out the problem with the original legislation very well. Could you provide any explanation as to why Section 91 was enacted in its original form?
Thanks, Mr. Chair. And Maria can perhaps provide just a little bit more background. I mean, this is sort of late 90s and around some of the health care acts and of the time. One thing that you had raised previously, and it's on whether there were any remaining bills that had this priority scheme. And so just as a forward to Maria's comments on sort of the history of that section and the history of the Act, I thought it was interesting, or to perhaps important to point out, that there are no remaining pieces of legislation that will have the oldest parent take priority over legal guardian, and we can provide more information around that, but I know that was something that we had talked about previously. And so with the proposed amendments, this Act will be now in line with the other acts that have a priority scheme for decision-making, so all of which provide that legal decision maker takes priority over another parent regardless of age. But Maria, please, if you want to go into the history of the section.
I'm sure thank you. This provision dates back to 1999, and it came about right around the same time as the Healthcare Directives and Substitute Healthcare Decision Makers Act in 1997, which has a priority scheme for decision-making in a timely manner. So I think, and I wasn't around back in the 90s, but I think the intention was because there is a concern around timely disposition of human remains and dignity to the deceased person, that a priority scheme be in place so that an authorized decision maker can be found quickly to make those decisions.
Thank you. And thank you, Minister. You anticipated and answered my follow-up question. I appreciate that. With respect to this amendment, in particular in relation to adult children, how does this amended provision compare to how this issue is handled in other jurisdictions throughout Canada?
Across the country, BC and Alberta are the only other jurisdictions that have priority schemes that are similar to ours. The further east you move, there are no priority schemes in place. So the disposition of human remains lies with the executor. If there's no executor under the will, then it would be an administrator if there's a dispute over human remains. I know I was surprised as well.
I'm very curious how that works, how that operationally, it seems like it would be a challenge in a lot of circumstances.
There's definitely a lot of case law in other jurisdictions, but BC and Alberta are very similar to our current framework. They came about around the same time.
Yeah. Thank you for that. As you well know, Minister, and I spoke about this in my adjourned debate just for the purposes of the committee, this was an issue that was brought to my attention and my colleagues' attention, Ms. Young, from a woman who had a pretty horrific story about her adult son who died in a car accident. And although her adult son had lived with her up to recently, had been, she was the legal decision maker for many years because she had left an abusive relationship because her ex, the father, was older than her. He ultimately was the one who was granted decision-making powers as to how to deal with the body and what the funeral would look like, which was very traumatic for her and actually has resulted in a lot of challenges in terms of accessing, being able to know when the funeral was going to occur and being able to access the body, frankly. So we wrote a letter, my colleague and I, to you, Minister, and very much appreciate how quickly you acted on this particular issue and how you were able to expeditiously move a practical solution forward. So hopefully another person in this province doesn't have to experience what that woman experienced. So just thank you.
Well, thank you for that. And again, won't reiterate anything that you said in terms of the tragedy of the situation. And correctly, there was the woman involved, I think around the same time, wrote to you and your colleague, wrote to my office and a colleague as well. And so we're pleased to be able to do this practical but important to carry out this change.
Absolutely. We don't always get to celebrate when we work together to achieve positive solutions, so I always want to make sure that we take the opportunity to point those out because they definitely do happen. So thank you for that. I have no further questions.
Thank you. Seeing no more questions, we will proceed to vote on the clauses. Clause 1, short title, is that agreed? Carried. Clause 2, is that agreed? Carried. Clause 3, is that agreed? Carried. Clause 4, is that agreed? Carried. Clause 5, is that agreed? Carried. Clause 6, is that agreed? Carried. Clause 7, is that agreed? Carried. Clause 8, is that agreed? Carried. Clause 9, is that agreed? Carried. Clause 10, is that agreed? Carried. Clause 11, is that agreed? Carried. Clause 12, is that agreed? Carried. Clause 13, is that agreed? Carried. Clause 14, is that agreed? Clause 15, coming into force, is that agreed? Carried. His Majesty, by and with the advice and consent of the Legislative Assembly of Saskatchewan, enacts the follows: the Funeral and Cremation Services Legal Decision-Making Protection Amendment Act 2023. I'd ask a member to move that we report Bill number 145, the Funeral and Cremation Services Legal Decision-Maker Protection Act 2023 without amendment. Mr. Gowdy moves. Is that agreed? Agreed. Carried. Any closing comments? Thank you. Any comments? Next on our agenda will be Bill number 146, the King's Bench Consequential Amendments Act 2023, Clause 1, short title. Minister Eyre, would please make your opening comments and introduce your officials if you wish.
Thank you, Mr. Chair. With me, Kara Moen, Crown Counsel at Legislative Services, and I'm not sure I properly introduced Darcy McGovern earlier, KC Legal Executive Director of Public Law. Should have done that. So, Mr. Chair, pleased to offer opening remarks concerning Bill 146. It is a companion to the King's Bench Act, which was passed in the spring of 2023, following the succession of the throne. The King's Bench Act updated the Queen's Bench Act 1998 and made some amendments to bilingual legislation to replace references to the Queen with references to the King. This bill continues that work by making consequential amendments to over 250 English-only statutes. And it's entirely housekeeping in nature, Mr. Chair, ensures that the name of our Superior Court and its rules will be accurately cited in our legislation. So with those remarks, I welcome any questions.
Thank you, Minister. We'll now open it up for questions.
Thank you, Mr. Chair, and thank you, Minister, for your opening remarks. Understanding that this legislation is housekeeping, I'm just wondering if there are any anticipated further amendment legislation required to deal with the secession of the throne in the future.
Kara can certainly add anything. My understanding is that there are about 600 amendments here to over 250 statutes that refer to Queen's Bench, Queen, et cetera. So that will all be updated herewith. And the legal effect of Queen to King, as you'll know, already took place with the introduction of the King's Bench Act in the fall. So this just cleans up all the statutes. Any other?
Kara Moen, Crown Counsel. That's correct. And I tip my hat to the drafting branch that does a very fine-tooth comb of all this legislation. And we may see some changes in regulations to going forward, but we're hopeful that we've caught the vast majority of the changes.
Thank you, and join with you in respect and empathy for the drafting branch who went through all of this legislation with a fine-tooth comb. I have no further questions.
Thank you. Seeing no more questions, we will proceed to vote on all the clauses. Clause 1, short title, is that agreed? Carried. Clause 2, is that agreed? Carried. Clause 3, is that agreed? Carried. Clause 4, is that agreed? Carried. Clause 5, is that agreed? Carried. Clause 6, is that agreed? Carried. Clause 7, is that agreed? Carried. Clause 8, is that agreed? Carried. Clause 9, is that agreed? Carried. Clause 10, is that agreed? Carried. Clause 11, is that agreed? Carried. Clause 12, is that agreed? Carried. Clause 13, is that agreed? Carried. Clause 14, is that agreed? Carried. Clause 15, is that agreed? Carried. Clause 16, is that agreed? Carried. Clause 17, is that agreed? Carried. Clause 18, is that agreed? Carried. Clause 19, is that agreed? Clause 20, is that agreed? Carried. Clause 21, is that agreed? Carried. Clause 22, is that agreed? Carried. Clause 23, is that agreed? Carried. Clause 24, is that agreed? Carried. Clause 25, is that agreed? Carried. Clause 26, is that agreed? Carried. Clause 27, is that agreed? Carried. Clause 28, is that agreed? Carried. Clause 29, is that agreed? Carried. Clause 30, is that agreed? Clause 31, subclause, is that agreed? Clause 32, is that agreed? Carried. Clause 33 coming into force, is that agreed? Carried. Schedule 1, is that agreed? Carried. I feel like an auctioneer for crying out loud. His Majesty, by and with the advice and consent of the Legislative Assembly of Saskatchewan, enacts the follows: the King's Bench Consequential Amendments Act 2023. I'd ask a mover that we report Bill 146, the King's Bench Consequential Amendment Act 2023 without amendment. Mr. Kiesig has moved. Is that agreed? Carried. Is there any closing comments on this bill?
Yes. Yeah, thank you. Since it's my last justice bill of the evening, I just want to take the opportunity to thank yourself, Mr. Chair, and the committee for their work, as well as the minister for her thoughtful answers to my questions, and all of your officials. Thank you for being here tonight, answering my questions, and for all the work you do on behalf of the province every day.
With that, I'd like to thank Ms. Saar for her work tonight, and thank you for all the good questions and the easy job. Yes?
I just noticed that we passed a motion for Schedule 1. There also is a Schedule 2, and I just don't want to have to come back here again.
No?
Page 9.
Oh, okay, that's right here. Look at that. I'm going. Okay. Where's that? Okay.
On page 9, right at the top.
Okay. Okay, Schedule 2, is that agreed? Agreed. Carried. We'll add that onto the list if everybody's in agreement. Thank you. Thank you for catching that, Mr. McLeod. Where did I? Okay, closing comments. Thank you. We will now move on to Bill number 148, Film Content Information Act, Clause 1, short title. Minister, please make your opening comments and introduce your officials.
Absolutely, my pleasure. Again, Mr. Chair, Denny Hugabert, Executive Director of FCAA. Karen Flantzer is here, Senior Counsel with FCAA, and Darka Tkach, Crown Counsel, Legislative Services with me. So pleased to offer opening remarks on this bill, Bill 148. Mr. Chair, the film industry has undergone significant changes since the existing film classification system was originally implemented. Digital technology, streaming platforms have changed how media is being distributed and consumed. Increasingly, film content is being downloaded over the internet or streamed on demand rather than being viewed at theaters or at home. That said, the film industry has also seen something of a renaissance since the pandemic, and the current act requires classification of films before they are exhibited to the public or sold or rented. It also requires that advertising associated with films be approved. Film exhibitors and distributors must also currently register with and submit an annual return to the Director of Film Classification with the Financial and Consumer Affairs Authority. Additionally, exhibitors and distributors must pay, that's currently, a fee of up to $440 per film for the classification of a film unless it's exempted from classification in Saskatchewan. This act will remove that fee, resulting in savings to operators of about $65,000. There is a certain amount of red tape for cinema operators currently. National exhibitors must at times pay multiple sets of classification fees in different provinces for a film to be viewed in Canada. Film industry stakeholders in Saskatchewan asked the government to consider ways to reduce the burden and cost for film exhibitors at large and small. This act, Mr. Chair, will modernize film classification, remove cumbersome and expensive requirements for cinema operators, and ensure that Saskatchewan film goers continue to make informed viewing choices. Exhibitors will now be required to provide information about a film's content to consumers in advance of exhibition. It's also important to note that the bill will still require that adult films be reviewed and approved by an entity authorized to approve adult films. And this proposed act will continue to ensure that consumers are provided with film content information that they need to make informed viewing choices, but as stated, will also reduce unnecessary red tape and compliance costs for businesses. The legislation and accompanying regulations will still require that film exhibitors provide detailed information on a film's content with the public, which could include the age of the intended audience, adult themes, violent, coarse, or obscene language, and substance use. And with that, Mr. Chair, welcome questions regarding Bill 148.
Thank you for your opening comments, Minister. I will now open it up for questions. Mr. Teed.
Yes, thank you so much for your opening remarks, Minister. My first question is just which stakeholders did the ministry consult with specifically about these amendments?
I have that list. Thanks, Mr. Chair, and certainly any additional comments officials can certainly weigh in on. So a consultation paper regarding the review of Saskatchewan's film and video classification legislation was posted on the FCAA's website on August 31 of 2023, and it was emailed directly to over 145 stakeholders, including all existing film registrants, the Saskatchewan Coalition for Tobacco Reduction, the Saskatchewan Medical Association, Consumers Association of Saskatchewan, and film industry associations. There was a news release issued on August 31, also of last year, inviting the Saskatchewan public and interested stakeholders to offer feedback on the consultation paper and the regulatory framework which governed film classification. And the FCA received 17 written responses, is my understanding, received them from parents, from consumers, exhibitors, distributors, industry groups, a consultant, and other film registrants. There were no responses, again, is my understanding, that were received from health advocacy groups.
And since introduction, have there been any further concerns or feedback brought forward by those or similar agencies? Anything new?
My understanding is that it's been largely no, very limited, if at all, and largely positive. Anything that officials want to add there?
Yeah, I'll just add, from consumers, no additional feedback or comments or questions. We've had a couple of inquiries from industry members inquiring about when this legislation might come into effect in anticipation.
Okay. In the opening remarks, it was mentioned that film advertisement had in the past needed to be approved before exhibition. Will that continue, or is that one of the red tapes that will kind of be taken away in this upcoming legislation?
Question, I'm sorry, Mr.
Yeah. It was just mentioning that film advertisement in the past had needed to be approved before it could be put forward. I'm wondering if that will continue, or is that kind of the red tape that's mentioned that these operators will be able to just go forward without having to approve that advertisement?
Yeah, that's being removed as well.
Okay, perfect. As I was doing a bit of a deep dive into film classification, I came to understand that we have our own film classification, but have kind of opted to use British Columbia. Us in Manitoba or Alberta, or sorry, Saskatchewan, Manitoba, and British Columbia kind of use a similar classification. Will there be any change to the way consumers see those classifications on posters? I'm imagining advertised or communicated through websites. Will we continue to maintain that kind of 14A, 18A, rated R type classification system?
Certainly, again, officials feel free to weigh in. So it's been more in terms of the BC aspect that you referenced. I believe you are referring to, so the classification system, which we currently are part of, through which we have to go through BC. So basically, so exhibitors and distributors currently get charged twice. So the current fee for age classification of a film in Saskatchewan, as I said, is $440. $220 is retained by BC, and $220 to Saskatchewan. So as it currently is to the film classification unit within the FCAA. Ontario went down this road. So I guess if there was any looking to another jurisdiction, it was perhaps more eastward in that sense in terms of how they had maneuvered around this. It really is taking out that middleman, if you like, of going always through the BC classification system, and the cost involved really for anyone who wants to show films, including, of course, in Saskatchewan, independent theaters, and so it's not only the bigger players. So it's really removing ourselves from that red tape, I guess, if you like.
No, that makes a lot of sense. My next question maybe kind of is answered along the same line as I was looking. The director of film content and potentially any deputies, are these new positions that will be created to facilitate this new Saskatchewan model where we won't have to rely on British Columbia? Is that kind of the line of that?
There are no positions in terms of this change.
Just in the legislation, it says that there might be a director appointed, a director of film content. Is
It's within existing staff. And so right now there's a director of film classification. Now under the new regime, it would be a director of film content.
perfect. I think that is all my questions this evening. Thank you so much.
Thank you. Seeing no more questions, we will proceed to vote on the clauses. Clause 1, short title, is that agreed? Agreed. Carried. Clause 2, is that agreed? Agreed. Carried. Clause 3, is that agreed? Agreed. Carried. Clause 4, is that agreed? Agreed. Carried. Clause 5, is that agreed? Agreed. Carried. Clause 6, is that agreed? Carried. Clause 7, is that agreed? Carried. Clause 8, is that agreed? Carried. Clause 9, is that agreed? Carried. Clause 10, is that agreed? Carried. Clause 11, is that agreed? Carried. Clause 12, is that agreed? Carried. Clause 13, is that agreed? Carried. Clause 14, is that agreed? Carried. Clause 15, is that agreed? Carried. Clause 16, is that agreed? Carried. Clause 17, is that agreed? Carried. Clause 18, is that agreed? Carried. Clause 19, is that agreed? Carried. Clause 20, is that agreed? Carried. Clause 21 coming into force, is that agreed? Carried. His Majesty, by and with the advice and consent of the Legislative Assembly of Saskatchewan, enacts the follows: the Film Content Information Act. I'd ask a member to move that we report Bill number 148, the Film Content Information Act, without amendment. Moved by Mr. Gruel. Is that agreed? Carried. I will now ask the Minister for some closing comments.
Thank you, Mr. Chair. Thank you to committee members. Thank you for your vigilance around subclause 2, very important. And I want to thank officials. One is very struck every year by the proverbial journey that is these bills. And so they go through many processes and much scrutiny, and it's all worthwhile in the end. But I do want to thank all officials for all their work, their very detailed work on all of this.
Thank you, Minister. Mr. T, do you have any comments?
I would just echo the comments by the minister. Thank you all so much for yourself and your team and committee members and all the staff here at the Legislative Assembly.
I'd also, too, like to thank the minister, staff, and all the committee today, and also the staff for putting up with us tonight. That completes our committee's business for tonight. I'd ask a member to move the motion of adjournment. Mr. McLeod, you're efficient enough. You can move it. Is that all agreed? Carried. This committee stands adjourned till the call of the chair.